This AI-generated podcast is for general information only and does not constitute financial or legal advice. Please consult a qualified professional. Welcome to the Luxembourg Fundcast, produced by Bertrand Mariaux, a regulatory lawyer qualified as Avocat à la Cour in Luxembourg and Paris. This show brings you reliable insights on Luxembourg regulations sourced from curated official references. This episode is current as of 18 May 2026.
Thank you. It's great to be here.
So imagine a credit institution watching millions of euros in collateral just, evaporate during a market shock. And purely because their margin call notice was sent to an unmonitored email address, which renders their enforcement rights temporarily paralyzed.
Yeah, that's a nightmare scenario, but it's completely avoidable.
Exactly. And that's why today we're doing a deep dive into the really unforgiving mechanics of Luxembourg Lombard loans and financial collateral management. Our mission here is to examine the strict legal reality of margin calls, the statutory framework governing enforcement, and, the precise operational documentation required to ensure a facility stays robust under pressure.
Right. And for those of you structuring or advising on these transactions, this deep dive is essentially a functional masterclass in aligning your contractual intent with the Luxembourg statutory reality. It's an essential topic because, frankly, the Luxembourg legal framework provides exceptional certainty.
But, and this is a big but that certainty is entirely dependent on strict documentary discipline.
Precisely. I mean, the law gives you the tools, but it absolutely does not assemble them for you.
Yeah.
So today, we're going to clearly establish how credit monitoring, custody mechanics, and security interests must all interact to create a legally enforceable structure, one that actually works when you need it most.
Okay, let's establish the foundations of this analysis. Before we even examine the operational triggers, we need to define the subject matter exactly as the regulatory authorities do.
Right, which means looking at the CSSF framework.
Exactly. Under that framework, a Lombard loan is explicitly defined as a loan collateralized by securities pledged for the benefit of the lending institution. So, if the borrower breaches the loan agreement, that institution may enforce the pledge and sell the collateral.
Yeah, that definition sets the regulatory baseline. But for the practitioners listening, there are really three concrete legal realities regarding how this operates in practice that you absolutely must know.
Okay, let's break those down. What's number one?
Number one is that a margin call is strictly a contractual demand to restore collateral coverage. That's it. It's typically achieved either by adding eligible collateral, repaying part of the loan, or, a combination of both.
So it's not some automatic statutory default?
No, not at all. It is purely a contractual mechanism.
Right. And number two really establishes the legal core of this whole structure, doesn't it? It rests on three distinct operational facts that must exist simultaneously.
They absolutely must. First, the facility agreement has to explicitly define the coverage test. Second, the pledge must secure those relevant financial obligations. And third, this is critical, the collateral must be explicitly in the possession or control of the collateral taker or their appointed agent.
Without control, you just don't have a perfected financial collateral arrangement under Luxembourg law.
Exactly. If you don't have control, the structure fails. And that brings us to the third must-know, which involves the Luxembourg law of 5 August 2005 on financial collateral arrangements.
Yes, the cornerstone legislation.
Right. So under this law, the enforcement routes found in Article 11, which include things like appropriation and sale, they have to be legally distinguished from the closeout netting mechanics governed by Part V.
Okay, wait, so both mechanisms are highly effective, but...
No, but they are conceptually and legally distinct tools.
Yeah.
Both must be addressed in your documentation. We'll explore exactly how they differ in a moment, but you cannot conflate them.
Before we get to the enforcement side of things, I really want to clarify a very common misconception we see in practice. And this relates specifically to your first point.
The contractual nature of the margin call.
Yeah. Often there's this tendency to conflate the security interest itself with the margin call. Like, if a borrower fails to meet a margin call, a lot of people just assume the bank is enforcing the margin call itself.
Oh, yeah. We see that confusion a lot.
So how should legal professionals formally distinguish the two when they're reviewing a file?
Well, it's a critical distinction, and blurring the two always leads to flawed drafting. The security interest, meaning the pledge governed by the Law of 5, August 2005, is a property right.
An in rem right.
Exactly. It's an in rem right attaching directly to the assets. It provides your ultimate protection and your right to enforce against those specific securities. The margin call, however, is purely an in personam contractual correction mechanism.
A personal obligation between the parties.
Right. It's just the lever you pull when the agreed collateral coverage ratio is no longer met. It's designed to correct the imbalance before enforcement even becomes necessary. You don't enforce a margin call. You enforce the pledge if and only if the margin call is ignored, and that specific failure constitutes an agreed enforcement event under your contract.
Oh, I see. So if the borrower ignores the margin call, the bank doesn't just automatically seize the assets based on that failure alone.
No. There has to be a direct contractual link stating that the failure to meet the margin call actually constitutes an enforcement event triggering the pledge.
The contract bridges the gap between the personal obligation and the property right.
Precisely.
Well, that makes perfect sense. So let's map this out. Let's look at the life cycle of a loan going bad and examine exactly how the Luxembourg framework governs the interactions between the parties. If we look at the actors involved, we have the lender, typically a credit institution, the borrower, who is the debtor, and the collateral provider.
And importantly, the collateral provider can be the borrower themselves or a completely different third-party account holder.
Right. And when structuring these arrangements, it's vital to note that the Law of 5, August 2005, presumes that financial collateral arrangements and netting agreements are commercial transactions.
Yes. According to Article 2, this applies to both merchants and non-merchants.
Which is a very significant structural advantage of the Luxembourg jurisdiction. Right?
It really is. It provides a uniform, highly protective framework regardless of the counterparty's commercial status. You are operating under a specialized financial regime that provides very high legal certainty.
Wait, let me just challenge the core premise of why we're doing all this daily monitoring in the first place. The CSSF operates on the principle that collateral is the institution's second way out in case of default or risk deterioration.
Right, the secondary source.
Yeah, meaning the primary source of repayment should always be the borrower's fundamental financial capacity. So, if that primary source of repayment is solid, why do institutions obsess over these daily margin calls? I mean, isn't the margin call just background noise if the underlying credit is fundamentally good?
That is an excellent question, and it goes directly to the objective of credit discipline. While the CSSF expects institutions to underwrite the borrower's fundamental capacity to repay, subject to specific exceptions recognized at origination for certain pure Lombard loans, of course, the collateral is your ultimate risk mitigant.
Because markets move fast.
Exactly. Markets move faster than a borrower's underlying financial health might deteriorate. The margin call ensures that the second way out remains fully intact and sized appropriately to the risk at all times.
So you can't just ignore it.
No. If you ignore the daily coverage ratios just because you trust the borrower's balance sheet, you are effectively converting a fully secured Lombard facility into an unsecured corporate loan. And you're doing it without pricing it as such and without regulatory approval to do so.
That clarifies the regulatory expectation perfectly. So the margin call is that contractual correction mechanism triggered when coverage ratios fail. The regulatory expectation requires the loan contract to be explicit and transparent regarding the specific mechanics of margin calls and the potential sales of pledged securities.
That transparency is entirely non-negotiable. And this actually highlights a really interesting jurisdictional dynamic.
How so?
Well, Luxembourg law governs the core security framework, the pledge itself, the account control, and the enforcement clauses. However, the credit monitoring layer of the facility, including how you assess the risk and trigger those margin calls, is governed by European Banking Authority and CSSF expectations.
So you're operating across two layers.
Exactly. You have a robust national property law framework for the security and a European prudential monitoring framework for the credit discipline.
Okay, and as for when these mechanisms are triggered, the timing of a margin call is purely contractual. It's triggered the moment the loan-to-value ratio crosses an agreed threshold. Right. But there are specific regulatory timelines that institutions must currently adhere to. For instance, Circular CSSF 22824 applies from 31 March 2023, and the European Banking Authority guidelines apply from 30 June 2021.
Correct. And to execute this properly, we have to look at Article 1.6 of the Law of 5, August 2005. It defines an enforcement event as an event of default or, and this is the crucial mechanism, any event whatsoever agreed upon by the parties.
Wait, any event whatsoever?
Yes. This means the parties have immense contractual freedom to define exactly what triggers the right to realize collateral, appropriate it, or effect a closeout netting provision. The statute does not force a rigid definition of default upon you. It just enforces the definition you write.
Wow. But if that contractual freedom is so broad, how do institutions actually document it without creating massive loopholes? That brings us to the operational playbook. For the counsel and execution teams listening, how does a firm practically sequence these requirements so they actually hold up under regulatory and legal scrutiny?
Well, sequencing requires absolute documentary precision. Let's look at what happens when a vague clause fails. If your contract simply says, the bank may call for additional margin if the collateral value falls, that is legally dangerous.
Because it's too ambiguous.
Exactly.
Yep.
For live execution, your margin call clause must be mechanically explicit. It must state exactly who calculates the ratio. It must state which pricing sources are used and exactly when those valuations are taken.
Right.
It also has to define exactly which assets are eligible to restore the margin and what haircuts apply to them.
So it's about removing absolutely all operational ambiguity. The playbook also requires outlining the specific notice methods and the client response timeframes. And crucially, the documentation must explicitly state whether noncompliance with a margin call triggers an immediate enforcement event or whether it requires a remediation step first.
Exactly. And beyond the legal drafting, there are strict qualitative requirements for the collateral itself. The pledged securities must be sufficiently diversified and liquid.
Which means applying prudent haircuts.
Right. Institutions are required to apply prudent haircuts to the valuations to buffer against market volatility during a potential liquidation period. They have to closely monitor both the value and quality of the collateral and maintain an early warning system. The goal is to ensure that corrective measures are taken in a timely manner well before enforcement becomes the only option.
Let's discuss the scope of the pledge itself. The pledge must precisely mirror the exposures outlined in the facility agreement. This means explicitly covering present, future, actual, contingent, or prospective obligations, provided that is the intended scope.
Yes, the alignment has to be perfect.
What happens practically if there's a mismatch between the facility agreement and the pledge?
Well, if the facility agreement creates a contingent obligation, say a guarantee or an undrawn commitment, but the pledge agreement is drafted narrowly to only secure present and actual obligations, you have a structural mismatch.
Oh, I see.
If that contingent obligation crystallizes and the borrower defaults, you cannot enforce the pledge to cover that specific debt because the property right was never attached to it. When market stress hits, that mismatch is exactly where legal certainty fractures. You have a theoretical right to repayment, but absolutely no practical right to the assets.
That's a sobering reminder that the documents must speak exactly the same language, which really brings us to what we might call the decorative clause trap.
The decorative clause trap, I like that term.
Yeah, because market practice clearly requires treating margin calls as strict operational control points, right? Not just as boilerplate text dropped into a contract to satisfy some template. Despite the clarity of the Luxembourg framework, why do we still see documentation fail under actual market pressure?
Simply put, documentation fails because the mechanics drafted in the contract are not practically executable by the operations team. Valuation notice, eligibility, and cure mechanics have to align with reality.
Can you give us a concrete scenario of a decorative clause failing?
Sure. Imagine your credit agreement states that valuations are taken at the close of business in London, but your custody agreement defines the close of business based on the Luxembourg market.
Oh, right. A time zone mismatch.
Exactly. Or consider a scenario where the credit document gives the borrower 2 business days to cure a margin shortfall, but the custody and clearing mechanics require 3 days to settle the incoming eligible assets.
In that case, the borrower physically cannot cure the breach in time, even if they have the assets and are perfectly willing to transfer them.
Exactly. The margin call, calculation, and the cure period are instantly vulnerable to dispute. Strong files are those where the credit agreement, the custody documentation, the pledge, and the client communication protocols all share identical definitions and trigger logic.
So they have to function as one system.
Right. If they do not, your clauses are merely decorative, and you will spend critical days arguing over definitions while the collateral value just continues to drop.
That alignment is the difference between legal theory and operational survival. Now, while the current market focus is purely on execution, and you noted earlier there have been no structural regulatory shifts in the last 48 hours, a prudent legal analysis must account for the future.
We always have to look ahead.
Right. We need to look ahead at confirmed governance milestones that will impact credit institutions operating these Lombard facilities.
And we should focus exclusively on confirmed, officially scheduled dates to ensure this remains practically relevant for everyone listening. First, there's the Law of 5, May 2026, which transposes CRD 6.
Okay, what does that involve?
This legislation reinforces internal governance requirements and introduces a harmonized prudential framework for third country branches operating in Luxembourg.
What does that mean practically for a professional listening right now?
It means that come May 2026, third country branches operating in Luxembourg will face a more harmonized standard. They will need to ensure and demonstrate that their internal governance, including their credit monitoring and collateral management frameworks, meet these updated prudential standards directly, aligning closely with the broader European framework.
Got it. And secondly, we have the CSSF timeline regarding internal governance. The CSSF has stated that Circular CSSF 12552 will be updated following the publication of the revised European Banking Authority internal governance guidelines. Those guidelines are expected by the end of the third quarter of 2026.
Yes. And finally, building on the transpositions we just discussed, the third country branch and third country banking services regime will officially apply from 11 January 2027.
So these aren't just vague trends.
No, these are hard dates. Institutions must factor these specific dates into their medium-term governance and compliance planning for their collateralized lending divisions. It's not just about having the right pledge agreement anymore. It's about having the institutional governance to monitor and enforce it legally.
To conclude this deep dive, we need to synthesize the statutory framework, the operational playbook, and these governance milestones into a final scenario.
Let's do it.
Consider this. An institution identifies a rapidly deteriorating position and needs to enforce its mechanics before market stress fully materializes and the collateral value drops below the outstanding loan amount.
The action required in that scenario relies on ultimate documentary discipline, having been established long before the stress event. You must perfectly align your valuation sources, your timing, your notice channels, the cure periods, and the enforcement event wording across the entire suite of documents.
The credit monitoring logic must be irrefutably recorded in the file.
Exactly. When you issue that margin call, there can be no ambiguity about how it was calculated, where the notice was sent, and exactly when the clock runs out.
And when that discipline is achieved, the result is a robust structure where any top-up, partial repayment, or ultimate enforcement follows the contract and the law of 5 August 2005 to the letter, which actually brings us back to the crucial legal distinction you mentioned earlier, the difference between Article 11 and Part V.
Right, let's clarify that. If the enforcement event is triggered, the contract and the law of 5 August 2005 allow for specific Article 11 routes. These include appropriation, assignment by private sale, sale on a trading venue, and public auction.
Let's look at the mechanism of that.
Well, a sale under Article 11 means you have to go out into the market and find a buyer for the collateral or appropriate it at a commercially reasonable valuation to discharge the debt.
Whereas closeout netting is fundamentally different.
Exactly. Closeout netting, governed by Part V, is essentially an accounting mechanism. You terminate the outstanding obligations and cancel out the mutual debts you owe each other to arrive at a single net balance.
Oh, I see.
If the market is completely frozen and there are no buyers for the securities, the sale route under Article 11 could stall. Netting, however, provides an immediate mathematical resolution between the parties.
So they serve different purposes under stress.
Yes. These Article 11 enforcement routes must be utilized alongside but clearly distinguished from closeout netting mechanics. You read them together in the documentation to maximize their options, but you do not confuse the mechanics of a sale with the mechanics of netting.
As we wrap up this masterclass, how should we objectively summarize the overarching value of this jurisdiction for these transactions?
Luxembourg is strategically relevant because its financial collateral regime gives parties broad contractual space, but that advantage only works when the credit, custody, and security documents are drafted as one coherent legal system.
That coherence is the standard every practitioner must aim for. As we close, I want you to consider a final thought. The Luxembourg framework mandates strict alignment of notice channels, cure periods, and valuation mechanics. But as the market inevitably accelerates toward automated real-time collateral monitoring systems, how will your static legal documentation need to adapt to govern algorithmic margin calls executing in fractions of a second? Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Subscribe to Bertrand Mariaux and Rigor Media on YouTube. Connect with Bertrand on LinkedIn at bertrandmariaux.com. All links in the show notes. This was the Luxembourg Fundcast.